would probably look similar to those two pictured there. There might be, certain differences here and there. And in this area, there's also some phreatic or some flowing wells that will flow without the need of a pump. So, like I said, they take all shapes and forms. What a water right is not. So I kind of hinted at a little bit. A water right's not the same as a share in an irrigation company. I know in this part, there are certain lots that have shares in water from Salt Lake City. So in that case, Salt Lake City owns the base right, and then they administer shares to shareholders. So when we're talking about water rights, we aren't talking about those shares. Ultimately, Salt Lake City would be responsible for protecting those water rights, and I assure you they are very aggressive at doing so. So if you have shares in anything from Salt Lake City, be confident that they are taking care of it. It's not a connection to a public water supplier. I mean, it's not the water that's coming through your water meter in your park strip. So you may be using water, but it's being provided again probably by Salt Lake City public utilities. So again, if we've reached this far and you say, hey, I have nothing to worry about, I have no water right, you can take off, and that's cool with me, all right? But we're going to start talking about a little bit of the historical context so you understand why we have a general adjudication. What's the purpose of it for, right? I know there's a lot of concerns that, it's just the government coming in, they're looking for one more thing to take. They've taken your taxes, they've taken this and that, they've made you apply for everything, and I get it. Yes, sir? So his question is it illegal to harvest rainwater without a water right? The answer is no. You can harvest rainwater in the state of Utah. The statute does require you to just record it on the. So on our website, there's a place where you can just say, hey, I'm harvesting rainwater, and there's some limitations to that. But that's not really our wheelhouse, and that's not what this is about. But the answer is yes, you can harvest rainwater to a certain amount. You simply need to register with the state of Utah. And to be quite honest with you, that was the Utah legislators that decided that that's what needed to be done. As far as the Division of Water Rights, it wasn't really we weren't really super concerned about people, putting the downspout into a rain barrel and using that on their lawn. But they felt it was necessary to require a law for that. So, did that answer your question? Yes. All right. But there is, if you go to our website, you'll be able to navigate to how to do that. And there's no fee or anything associated with it. They simply put it in the law that you had to register with the state of Utah. And the only reason for that is so that we can understand where water is being used and be able to plan for the future. So that was the purpose for that registration. Again, I understand that there's this philosophy, it's maybe Big Brother checking in on you. I don't know what we do with that data other than collect it to understand how much water is being used and where it's being used. And that's similar with the adjudication process. So, good? The government sticking its nose in God's business. Well, what else does government do, right? That's our favorite thing to do. No, in reality, if you kind of look at how water rights developed in the West, I know you're just joking, but it's an important principle that, hey, water falls on watersheds, and people who have grown reliant on that water downstream have applied for water rights. And so can you imagine if suddenly, let's say the whole Wasatch Front became the property of the Forest Service? Not hard to imagine, because it pretty much is, right? And they say they decided to harvest rainwater. Well, suddenly, if they put dams everywhere there and collect all the water, that impairs people downstream. So I understand the concern about, but the minimal amount of water you collect on your roofs and store, quite frankly, it gets lost in the rounding compared to the other big water uses in the state of Utah. So it's not a huge concern. It's just something that we feel, or not we, but the Utah legislature felt needed to be tracked and monitored. So again, I am not a rainwater harvesting expert. There are people that are. They reside in the Division of Water Resources. I suggest you go up there if you have any questions on how to capitalize on that, and they can help you through that. So the historical context of why we do general adjudications. We know the story, or probably all familiar with the story about Brigham Young coming in the valley. July 23rd, 1847, they had an advance party. Not soon thereafter, they started diverting water from City Creek just to moisten up the soil so they could begin planting a late season crop. And so water development and diversion started right away when the pioneers entered the valley, and even obviously before that with the Native Americans. And of course, this is the place, and they built a shopping mall there. Sorry, jokes are old, but maybe they're new to some of you. In 1848, Brigham Young declared that the waters shouldn't be owned by private ownership, that they belong to all the people. This is kind of a tenet of existing water law, that the waters of the state of Utah belong to the public. Now, the state of Utah administers those, but in the statute, they are owned by the public for the public's benefit. Well, from 1847 to 1850, what we now know as Utah went from being a part of Mexico to this kind of quasi-ecclesiastical state of Deseret to the territory of Utah. So it went through this transformation, but people continued to divert and use water regardless of the existence of any laws or any rules. You can imagine that because of that, the water was generally diverted on a community basis for the immediate needs of the people or the settlers that would go up and down Utah and the west and settle their territory. The doctrine of priority, that doctrine of prior appropriation, kind of evolved from church leaders' recognition of the people who settled there first and put all the effort into building these diversions, these ditches. They had senior priority, and then later on settlers would be able to come and divert a secondary system. And then they kind of mingled that with the doctrine, the mining doctrine of straight priority, first in time and first in right. Because there was no real infrastructure, no real government per se, all the conflicts were settled by ecclesiastical channels. So you kind of had these bishops' courts that would act as provided judicial process for people to satisfy complaints. And then you had stake high councils, which would act as like the appellate court. So if they disagreed with what the bishop had to say, they'd go to their stake high council and have them rule on the issue. So as you can imagine, that without that structure, the LDS Church kind of filled that vacuum. So that's what happened, and a lot of those diversions, and a lot of those early water rights were established through those channels. Well, in 1852, the First Territorial Legislative Assembly made an attempt to bring some other type of enforcement or structure to the water rights appropriation process, and they authorized the county courts to become to have control of all timber and water privileges. However, Salt Lake County was kind of the only county that really embraced that, and if you can even say embraced it, it was largely ignored for the most part. And in any case, these county courts, these were appointed by the people by popular vote. So the same people who were doing the bishops' courts and the high council were the same people at the county court. So it was really not much difference anyways, but it wasn't really followed much throughout the state of Utah or the territory of Utah at that time. In 1877, the Desert Land Act was passed to promote homesteading of arid and semi-arid public lands. As a result of that act, it severed title of the water from the land, meaning you didn't have to own the land upon which the water was running by. You could divert it here, convey it all the way down here, and use it on a completely different parcel of land. So through some subsequent court case precedent that was established, but also delegated authority from the federal government to the state and territorial governments to administer water rights. And a lot of us may think that's kind of a foregone conclusion, but if you think about it, all the land patents, all the land, the homesteading, that was all controlled by the GLO, the Government Land Office at the time. So you might think that water would follow suit. Well, this act essentially gave authority to the local territories or states to become the administration framework for those water rights. In 1880, so like I said, the 1852 acts kind of became, it didn't really work, and so they tried to do something else. They appointed these county selectmen who would go and kind of act as commissioners or what do you say, ex officio water commissioners. Again, it was pretty much ignored, and I think there was a ruling that was found unconstitutional based on state law or on territory law, and so, because you had this appointed person acting in the capacity of a judge, right? And they wanted to separate the executive from the judicial branch, and they felt that was a conflict in there. So again, nothing was really followed. As a result of that, confusion continued to, in spite of the church's best effort, in spite of the legislature's best efforts. And the church continued to administer and decree water rights. And this is manifested in an example I often cite in the 1879 High Council decision, which divided the Spanish Fork River. And if you look at how that Spanish Fork River is divided to this day, that High Council decision was the basis for how it is currently now divided among the different irrigation companies. So you can see some long-lasting effects as a result of how the church molded some of these diversions. So moving into historical context and statehood and beyond, and I know this is, for some of you this is like super boring, but I promise you I'm going to get to why this is important. In 1896 we gained statehood. There was some debate over whether, with the creation of the state, whether the state should take control of all water rights and kind of grab them all from everyone. And as a result of that, there was a lot of debate, and they decided, hey, we're not going to even talk about water. All we're going to do at this point is put one provision in the Constitution, Article 17, that says, all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. And what that did, in essence, said, hey, if you've been using water, you continue to have that right, regardless of the statehood, and regardless of any law that's passed subsequent to this, because it's in the Utah State Constitution, right? Trump's state law, or it is the state law. So, following that, in 1897, they felt like they needed to appoint someone, the state engineer. The Office of the State Engineer was created, and his job was, in essence, to go and create hydrographic survey maps to see where these streams were diverted, see what the capacity was. And they were also, but however, that state engineer still didn't appropriate new water rights. You still had to go kind of hammer in your claim on the river and then go file it at the courthouse and the post office if you wanted to appropriate a new water right. Again, largely ignored, although I have seen those. They have come up every once in a while, and every once in a while you see them, and they actually form a basis for some of the water rights in this valley. People will bring those claims in and show us, hey, this is actually claimed back in 1892 or something to that effect. Well, in 1902, the United States Reclamation Service, what we know now as the Bureau of Reclamation, was established. And its job was to reclaim the arid West, right? And so to secure these federal funds for big projects, the Bureau refused to do big projects in states where there wasn't a comprehensive water law, because the last thing they wanted to do was come in here, spend all this money on these big dams and these big reservoirs, and then find out they didn't have the rights to fill them. And so what they said is, hey, states, get your acts together. If you want a project, then you're going to have to pass a water law. Otherwise, we don't feel comfortable in coming in and building these projects. So it's no coincidence that in 1903, Utah did just that. They passed the first comprehensive water law that provided for appropriating new rights, as well as recording all those existing rights that had been going on since the pioneers came in the valley, and then also for adjudicating those rights. However, the legislature failed to provide funding to the courts, because in essence what it did is said, all right, we're going to provide a mechanism, courts figure out, adjudicate these existing rights. And the courts just kind of said, how? You know, they just didn't know how to do it, and they didn't really get any funding. And so it was pretty much languished, and it was ignored again. So in 1919, the legislature finally figured out, all right, what we need to do is give the state engineer the authority to prepare a proposed determination. And so what that means is the state engineer goes in with his expertise, identifies these water uses, identifies the irrigation, the stock, whatever uses there are, and he creates this proposed determination that he then hands to the court, and then the court rules on that proposed determination. So it kind of eases the burden on the court a little bit by making the technical expert provide that recommendation, and then the court has it in front of them, or him or her, and they can rule on it accordingly. And that's largely what is the framework we still operate on today. So prior to 1903, when water law was first established, you didn't need a water right to divert water. After that, you had to appropriate a right. Well, groundwater was kind of considered free water, right? It's like a free chicken, right? You just take it if you could find it. Well, in 1935, they kind of came to the conclusion that groundwater and surface water, it's all kind of the same water. There's intermingled. So we need to have the ability to track and monitor rights that are being diverted out. So in 1935, the legislature passed a law that you had to you had to appropriate new water rights for any underground sources. But that meant that prior to 1935, if you had a well, then you were grandfathered in what we call a pre-statutory right or an underground water claim. And we'll talk a little bit more about that. And I know a lot in this area, a lot of the wells that are in existence fall under that statute or fall in that time frame prior to 1935 and are probably grandfathered in for all intents and purposes. So what's the historical case for the adjudication? Well, prior to that comprehensive water law, water rights kind of fell into typically a combination of 5 different categories. You had those rights that were decreed by ecclesiastical leaders. You had claims that were filed for record at the county. You had rights that were decreed by a court, and they typically involved limited parties. You had contracts or agreements among limited parties. And then you had claims that were never manifested on any record whatsoever. You had people that were irrigating up in the mountains. They were diverting. They really had no need to file a claim, so they never came forward. And we still get those every once in a while. So as a result of that, there were a number of issues. First, there was no public record. Because there was no record, over-appropriation of the stream and the groundwater was pretty common and pretty rampant. Often rights weren't defined until they came into controversy, meaning until people came and sued each other or took each other to the bishop's court or the state high council, whatever, and then they were defined. So, every 2 years, the state engineer is obligated to do a biennial report. Well, in one of his first biennial reports, the state engineer, observing the fact that he had all these existing water rights prior to the appropriation law, he made this statement. He said, "The definition of existing rights appears to be of first importance. It is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made a public record." So in his mind, we were supposed to adjudicate all the rights in Utah before we even started appropriating rights. Well, as you can imagine, that didn't happen. And the adjudication that we're talking about right now actually started in 1936. We're just finally getting around to your neck of the woods. Lucky you, right? So we'll talk a little bit more about that, but it's been a process that's been going on ever since 1919. These general adjudications have been taking place throughout the state of Utah. So what is a general stream adjudication? As the name implies, it's an action in state district court. It binds water users and the state engineer. So the Division of Water Rights, it takes its heraldry back to the state engineer's office. So Kent Jones is the executive director of the Division of Water Rights. He's also has that historic title of state engineer. So when I use that term, just think Division of Water Rights. It's governed by that section of code, titled 73, Chapter 4. And as you can see in the picture, it may be a little bit hard to make out some of the text. All of these different colored splotches on the state of Utah represent a different general adjudication. The general adjudication that we're referring to is this purple splotch right here. And it's called the Utah Lake Jordan River General Adjudication. It says 1944 is when it was initiated. It's actually initiated in 1936. And then the court said, all right, we've had enough of this litigation. We're just going to turn it into a general adjudication and bring all parties in. Originally, it started with Salt Lake City just suing like 1,000 people on the Jordan River. They felt it was too complex to just do it to that, so they brought everyone in. And I'm summarizing a great deal in that. So this purple blob takes in the Salt Lake Valley, but it also takes in Utah County, Goshen down here, and Nephi, and up into Heber as well. So the headwaters of the Provo River. So it's a pretty big area, and it's a very populated area. So the general adjudication, in order to do this, has to take it off in bite-sized pieces. And so the Liberty Park Subdivision is one of those bite-sized pieces. Now it's small compared to some other bite-sized pieces, mostly because it's a densely populated area, and there are a lot of water rights within it. So why do we conduct a general adjudication? Well, you remember this guy. We want to bring all those claims on a permanent record. We have the water rights that were diverted prior to 1903. Diligence claims is what they're often referred to. So those are surface waters that were diverted prior to 1903. We refer to those as diligence claims. We also have underground water claims. Those are the wells that were drilled prior to 1935. We want to make sure those come on the record so we know where they're at. We also have these things called Federal Reserve rights, and I won't get into too deep on that, but in essence, It came about as a result of the Supreme Court ruling that an Indian tribe on the Fort Belknap Indian Reservation, by virtue of the fact that Congress laid aside that reservation, there was an implied water right that went with that reservation. And so that doctrine has subsequently been applied to other federal reservations, such as national forests, national parks, national monuments. But the general adjudication, and let me back up a little bit, because you can't sue the federal government without their permission, we could never force the federal government into quantifying those water rights until Senator McCarran from our neighbor state Nevada passed into law the McCarran Amendment, which said the state can sue the federal government in state district court, which is pretty unique, and force them to quantify their water rights. And so a general adjudication is the only mechanism that I'm aware of that makes the federal government come play ball on our terms. And so it's pretty significant in that regard. Now in this area, I don't anticipate there being much, if any, probably close to zero Federal Reserve water rights. However, as you go up into Forest Service country, they do claim Federal Reserve rights there. So it is a big issue in this area, maybe not this particular subdivision. Another reason we want to do a general adjudication is to avoid everyone suing each other. We just kind of want to get it done and once and done, right? We want to remove or reduce rights that have been wholly or partially forfeited or abandoned. So we all know that the face of Salt Lake County has changed over time. You know, it used to be fields and horse pastures and those types of things back in the days, and it's become more and more urbanized. Well, as places have become more and more urbanized, a lot of these water rights have fallen out of use and become abandoned. And in the west of the Mississippi, it's kind of the rule that if you don't use water, it's such a precious natural resource. If you don't use it, then it reverts back to the public to be diverted. So it's a use it or lose it. And in the state of Utah, if you don't use a water right for 7 years or more, it's subject to forfeiture. And so a general adjudication, part of its mission is to see which of these rights have long since been abandoned, so we have an accurate record of what water rights are still being used in order to plan for the future, and then allow other junior appropriators to use their water rights if those other ones have been long since paved over by the Walmart parking lot, right? And finally, we want to obtain a comprehensive decree on all the water rights within the respective drainage. So at the conclusion of this, we hope to go back and get a decree from the judge, and if you have a water right, he'll decree your water right is valid. And that's the ultimate objective. But it's a way of confirming those rights that existed prior to the statute coming into being, because only a court can really do that, because it's a property right. Now, the state engineer has been authorized to appropriate new rights, but ultimately the court adjudicates the rights associated with the pre-statutory condition. So the process. The process is kind of a three-phase process. We have this initial phase that we're kind of in now. We're step 4 there, we're conducting the public meeting. We've sent notice, summons. You received summons in the mail with the notice. We've published notice in the newspaper. We'll be publishing summons in the newspaper here shortly. The next phase is, following this, in a couple weeks, you'll receive a notice to file a claim. And I'm going to go over that in a lot more detail here shortly. And then you'll file the claims. People have 90 days to object. Again, I'm going to cover all this in greater detail. And then we have another public meeting like this. And then we do it again. We come out with a proposed term. We investigate claims. We come out with our recommendation to the court, and we hold another public meeting. So you can see we're trying to be as open and transparent as we possibly can. And I hope that is conveyed, that feeling is conveyed to you. If you ever feel like it's not open and that, please come talk to me, and we'll see if we can't get your concern resolved. But let's dive into these a little bit more. So I mentioned about the notice to submit claims. So here in a few weeks, we're going to mail you, those who receive the summons will receive a notice to submit a claim. For people who are owners of water rights on our records, meaning we have a database of people who have appropriated water rights, and it has their water right number and their names and their addresses. So why? Yeah, it's a good question. So he's asking, is that why we're here? Why you're here is actually, in order to be as transparent and provide as much due process as we can, we obtained the names of all the parcel owners within that map boundary and sent notice to everyone, regardless of whether you owned a water right or didn't, because we wanted to make sure if you did have a claim that you received that notice. And so you may just be a property owner, you may not have a water right, and you would still receive these notices.
Can you make a claim for water?
Can you make a claim for water? We certainly hope you will if you have a valid claim. Now, if you're looking to create a new water right, there are other mechanisms to do that. The basin's closed to new appropriations because we've been so severely overdrawn. The way to acquire a new water right would be purchase a water right from someone else and then move it in, and we can talk that later if that's something you're interested in doing. But if you have a well that maybe is not a water right on our records, we would highly recommend that you file a claim as part of this, or else risk losing it. Okay, so that's why. So you kind of have this incentive to participate. Otherwise, you risk that type of penalty. I saw a question back here in the corner.
So if you have a well on a different property in the same area, can you actually close that well and open it up on the new property?
So his question is, if you have a well in one part, can you close that well and open it up elsewhere? It requires, there's a process to do that's called a change application. So in order to move it from one location to a new location and divert that same water right out of a different well, there's an administrative process that requires, and that's not part of the process we're talking about tonight, but there is a way to do that, and we can certainly answer those questions. I can direct you to the person who would help you through that process. Sir, and then ma'am.
Salt Lake City is administering a lot of our irrigation water in this area that you're talking about. And I guess they are picking up the Jordan River water or as part of that. Our water rights were, really back to the original date and time from the Parties Canyon. So, the city contracted with us as the user to provide us with water.
Right.
We built the dam
Right.
up in the canyon for the culinary water. And so, I guess, for most of us, if the city is involved in this process, they're...
So he yeah, I know. So I'm vaguely familiar with this concept. So he's describing kind of an old contract. So back in the day, Salt Lake City, so there used to be water rights that were diverted out, and there still are, out of Parley's Creek that would flow down and irrigate people's yards in Salt Lake Valley. Well, that was really clean and good water, right? And so Salt Lake City entered into negotiation with these groups of water users and said, hey, we will provide you water, our dirty, carp-ridden, dirty, nasty water out of Utah Lake, which is good for irrigation. Yeah, which is great for irrigation, does the job just fine for irrigation, right? We'll give you that if you'll give us access to your water and that we can then use to turn into drinking water, which is easier for them to clean that water. Now, the details of that exchange is kind of what we call it. To me, I'm not an expert on that, but that's something that we have come across in previous subdivisions, and subdivision just to the north of us. And we are working with Salt Lake City to understand how that works and what needs to be done in order to protect those rights. At this moment, I believe that it's not an issue because I believe Salt Lake City owns the rights, right? They acquired the rights in exchange for providing that service, and now they administer that irrigation water. And there's maybe some finer points to that, and I really don't want to get into the details of that here, but afterwards let's talk. But to put because I'd like to proceed and make sure that other people, if you don't mind, but we can talk those finer points. But we will figure that out, and whatever needs to be done to protect those rights will be taken care of. And if you feel like it's not being protected and you still want to file a claim even though you're unsure whether you should or not, feel free to do so, and we'll make sure that we'll look at it and make sure it's taken care of.
I just think for a lot of us that if the city is taking care of protecting our rights, then a lot of this is moot.
Well, there are a lot of individual wells, but yeah.
But for my particular case, and I know for a lot of people,
Yeah, you get water that's coming down the gutter, and you turn it off and turn it in.
and that's the right that we have.
Mm-hmm.
And I would love for it not to be carp infested, but
Or algae infested, right?
or whatever.
Yeah.
We've had some ugly stuff.
But you're right. But at the end of the day, Salt Lake, you're right. It may be moot for you, but I would still encourage participation.
That was my question.
And we certainly wouldn't push you away or try to brush you off. We want to make sure your concerns are taken care of. Ma'am, did you have a question? So this is a good question. So her question is, we've had a well in our property for a long period of time. If we haven't been using the well, are we subject to forfeiture? The clean answer is if it's not been used for 7 years. So the book answer is if it's not been used for 7 years, it's subject to forfeiture. However, I'm going to just say this, kind of like stomp my foot to as a clue to everyone to pay special attention, right? If we come out to evaluate your claim and the well's working and you're irrigating with it or you're running it to your house, we're not going to be CSI and try to figure out if that was just barely done. Our hope is that people will use their water rights and people will protect their water rights. So like I said, the hint is get your water rights up and running and make sure that it's functional. If you can't do it, then yes, it may be subject to forfeiture. I would. I mean, if I've earned your position, yeah. I guess I wasn't clear enough. But yeah, I think you talk to any of your neighbors. I think that's the consensus. All right. Sorry, I can't hear this lady's question. That is true. If you touch it with, so the question is, or the statement is, I have a house, I have, it sounds like subterranean water running beneath it in some capacity, probably in some type of conveyance system associated with an irrigation system. She called a government official about it, inquiring with respect to whether she could use it, and the government official said, no, you may not, that would be breaking the law. And there's truth to that. If you don't own a share in the irrigation company, it's not fair to take their water, right, without compensating the company for that use. So long question, short answer is, yeah, you probably will be breaking the law if you tap into that. I would, if you feel like that's incorrect, contact whoever owns the pipe or the water. I presume it's Salt Lake City Public Utilities, and see if there's a way you can acquire a share in order to use it for irrigation. But if that's what they've told you, I'm not sure that I can disagree with that. That's the same water. That's irrigation water. So she's asking about the, and we may have to take this offline because I don't know that this applies to everyone in the room, but my understanding is Salt Lake City administers this open ditch irrigation system. People, property owners are shareholders, whether they know it or not, but those are tied and they administer water to these property owners. And my understanding is they send water down, people take their turns on the ditch and divert, whether it's a ditch or a gutter in the road, right? And turn water into for irrigation. So again, that's water that Salt Lake City owns or at least distributes on behalf of their clientele. I have a question over here, sir. And we might have to kind of push through this.
Well, they're pretty luxurious. In and of the fact that I live in the Liberty Park Subdivision, I contacted the city and I said, I had to have had a well on my property at some time. Where is it? Well, we don't have to tell you. And then following up with these ladies, this is all in 1902.
Okay.
But you're stating.
Is there a question in there?
Somebody in 1902 says, hey, we got potable water from the city, we're not going to use it, blah, blah, blah. I wasn't elected.
Okay, so I'm gonna say we're gonna stick to, if there's a question for the broad group, the question I think that what you're getting at is, can you locate the well and somehow resurrect it? Again, I'm gonna go back to what I've already said. I think I've spoken that point already. So I understand there are a lot of questions I want to answer, but I want to make sure that they're questions for the whole group. All right. If you feel like it's an individual onesie-twosie question that applies specifically to your scenario, I promise you, I'll stay here as late as you want and I will answer them. But let's make sure we're allow people to proceed. So I'm going to take one more question, and then I'm going to get through this slide. All right. You're up.
Okay, I don't see a well in our property. How do we find out if we could claim?
The question is, I don't see a well in my property. How do we find out if we can file a claim? My answer would be, if you don't find a well in your property and you haven't been using it, then there's probably no chance you're going to be able to file. You can file a claim, but we'll come out and we'll probably recommend that it be forfeit or disallowed or whatever. Okay. I understand. It sounds like a unique scenario, and I will talk till your heart's content after this meeting. So let me get through these slides, all right?
Quick observation for the whole group.
Okay.
You can go online to the Division of Water Resources, and you can see where they have proxy well rights in that area by a map.
Yeah, so that's a good point. So there's a map interface that's actually Division of Water Rights that has it. And afterwards, I will show it to you, how to get to it, how to review it, and how to access what this gentleman's talking about, where you can actually see icons of where we have our records. It doesn't show where, if we don't know where it is, obviously we can't tell you where the well is. But if it's on our records, we have icons that kind of plot on top of aerial imagery. I'm going to get through this slide now, okay? And then you have some questions. All right. So, well, a little bit of a rabbit hole there, and I know, I promise you, I can't answer it.
I think the questions these two have asked are pretty much a very majority of us would like to know if we don't have a well. Because, like, I bought my house.
If you don't have a well, you probably don't have a claim, you probably don't have a water right.
I find houses underneath my ground. I find a bunch of stuff. But, like, I think there's multiple people that would like
All right, well, I'll answer that question. So here's the question. If I can't find a well, what do I do? If you don't have a well, I will save you the time right now and tell you you'll probably not be recognized for a water right. Okay? That is pretty straightforward. I try to dance around a little bit, kind of leaving windows of optimism out there. But at the end of the day, if you don't have a well and you go on the scavenger hunt looking for a well, the chances of finding one that's operational are probably pretty slim, because I would suspect that by this point in your life, you would know that you have a doggone well that's leaking every spring because it's flooding your yard. All right. So as I say, if you have a well or a water right, you're probably pretty aware of it. So hopefully that's been clear enough at this point. Now I really am going to get through this slide. All right. So for property owners, we will send out blank water users claims along with this notice. For people who are owners of record on our water rights database, they'll receive the notice as well as with a water user's claim that is fashioned after the data on our database. So it'll look like a printout, and it may not, it'll have all the information already populated with respect to what we have for that water right. So if you're that person, lucky you, you can just kind of line it out and sign your name and send it in. If it's a blank claim, you may take a little bit more work, but we will bring it in. We will help you fill it out. We'll sit by your side. We'll show you on the map, like this gentleman said, where we think that is. Or if you think you have a well, it might be this water right. We'll try to pin it to a water right. And if we can't, we'll still help you to file your claim. Okay? So once you are ready to file your claim, so once you receive that notice, you'll have 90 days to file that claim. Okay? If you don't file a claim, you're going to be left out. You miss your opportunity to file a claim in the future. Now, the state engineer has an opportunity to grant one 30-day extension. If you come in prior to that 90-day filing period and say, hey, I need an extension, it's automatically granted. You just got to make it known in writing, and we'll help you out. But after that 90 days, it's pretty tough to get a claim in. So file early if you can, okay? File early and often is what I say. Maybe not often, but at least early, so you can beat that 90 days. It's not worth it to try to see how close to that 90-day time frame you can get, because I guarantee you, we've had people try it, and they've been 1 day late, and we can't accept them, or we can't recognize them by virtue of the statute. Not that we don't want to, it's the statute's very clear. Once we receive your claim, we'll do a field investigation. That's what Josh's team will conduct. They will attempt to make an appointment. If you leave some contact information, preferably a phone number, on the claim, we can call you up and try to make contact so you can show us how your water right is being used. It's a lot easier if the person's there and say, this is my well, this is how I use it. It's just a lot easier for us. So we're not trying to skulk around at night trying to find a water right in your backyard. We want you to be there while we're trying to find that, and so that you can help us, and so that we can also recognize the full beneficial uses associated with your right. So we'll evaluate your claim and we'll map it. And then for those who fail to file a water right, those water rights go onto this list of unclaimed rights. Okay, so if you're a water right owner of record and you fail to participate, that water right will go on the list of unclaimed rights, and that list of unclaimed rights will then get published. Will get mailed out to the same audience here where they can access that. And then people have 90 days to file an objection saying, hey, I see my water right on here, I object, I wanted to file a claim, I didn't because some valid reason. And input valid reason there, wherever it is. Hopefully it's a valid reason, hopefully it's not because I was just watching TV. You have a question, sir?
I do. When you come out to do your inspection, will it be this year or will it be next year?
His question is, when we come out to do our investigation, will it be this year or next year? I anticipate that we'll begin investigating claims as soon as we get them. So I expect the claim investigation process to be completed by fall, depending on the number we get. But yeah, it's going to be, we don't like to let these things sit for very long. And it's hard, we still do it in the wintertime because we can rely on aerial imagery to demonstrate, whether something's been irrigated or not. But it's a lot easier to verify these in whether that's appropriate. Did you have a question, sir?
Hey, where does the list of unclaimed rights come from? Does that originate from transfer of property?
No. So he's asking, where does the list of unclaimed rights come from? So let me kind of help you envision this. So on our database, so in this area, let me see if I can just bring them out. I'm going to kind of fast forward to, I'll come back, promise. See that? All those green little dots? Those are all water rights of record that we have. Okay? After this meeting, we're going to have big printouts of these maps out in the hallway that you can all gather around and take a look, see where your house is at, and see if one's nearby. But this is also all available on our website. So imagine all of these water rights. Now imagine that 75% of people of these water rights never get filed, which is about what happens in these types of areas. Is that people don't claim 75% of them, not because they don't want to, but because they've been paved over or abandoned or filled with concrete, those types of things. And so those rights that we don't receive a claim for go on this list, and we call it the list of unclaimed rights. Okay? So let me go back to where I was here. And so we send out notice to people, and in that notice there's a little link to our website where you can download this list. And you can say, hey, this water right, that's actually my water right. Now I don't want it to be on the list of unclaimed rights because if it goes on the list of unclaimed rights and the judge decrees it, it will be abandoned and you can never use it again, right? It'll be decreed abandoned. So that's where we generate the list. It comes from our database. We have these many rights, these many get claims filed on them, these many don't. Those we take, we put on this list, and then they become abandoned. Okay? Okay, I think I covered that. All right, you have 90 days to file an objection to that list, as I said. Again, it's that 90-day time frame. So if you don't like the list, and we'll have a public meeting like this, very, very similar to this, where we'll have more opportunity to ask questions and have a dialogue. Following the publication of that list, you'll have 90 days to file an objection. We have to resolve those objections before the judge can decree it. So if you say, hey, I object, my right should be on that list, we've got to resolve that. Now we might litigate it. We might say, yeah, well, you have no reason. Your reason for not filing a claim is not valid, so we might oppose it. But if it is a valid reason, we won't oppose it because we want people who have valid reasons and valid water rights to participate and have their rights recommended. We're not, like I said, we're not out to get rid of rights. And so we have to resolve all those objections before the court can issue a decree on that list of unclaimed rights. Okay, so now we've gotten rid of all of the claims that weren't filed, right? All the water rights where there's no claims. Now we're only dealing with water rights for which a claim was filed. You'll remember our team are going out and they're reviewing those and investigating those. Well, they take that, they come up with their assessment of those water rights, and they compile them into one book called a proposed determination. So that's the official recommendation of the state engineer to the court as how the water rights should look like and how they should be distributed. And so again, similar to the list of unclaimed rights, we publish it, we send everyone in this room notice. Actually, I take that back. Notice will only be given to those who file a claim or who desire to receive notice, all right, who come forward and say, I want a copy of that proposed determination. So it'll be a pared down list of notice for the proposed determination. We'll have a public meeting to discuss the proposed determination. Now, in that proposed determination, you might say, well, I'm claiming 50 acres of irrigation, and you might just say, I'm going to go crazy with this thing, and I'm just going to make a huge claim, and then I'm just going to sell this and make millions of dollars, and life is going to be awesome. Well, we're going to come out and investigate it, and we're going to say, well, you really got like a 1/4 acre of irrigation, and that's what the recommendation makes it into the proposed determination for the judge. So when we're coming out to evaluate this, regardless of what your claim is, we're going to go out and see what the facts on the ground speak the truth, all right? Again, you'll have 90 days to object. These objections can be anything. And in some case, we may come out to evaluate a claim and we can't find any evidence of a well, can't find any evidence of beneficial use, and we'll recommend to the court that that water right be disallowed, all right, that it not be recognized. Well, once that's published, people have 90 days to object. You might have the individual who had his water right disallowed say, I object, my water right shouldn't be disallowed because of this and this and this. Or you might say, or it might be an objection to someone says, hey, this person has said he had a water right, and I don't think he does. So you can have objections against your own water rights, you can have objections against your neighbor's water rights, and those have to be resolved as well by the court before we can get a decree on that particular proposed determination or the state engineer's recommendation. Confused yet? Well, we're near the end. So that's really the culminating point, is once we get a decree, then those who have valid rights in the proposed determination now suddenly get them, gold-plated, and they become decreed rights, which is kind of, a good thing. It's the thing you want. It's like it's a great status to have. People like to have decreed rights. Okay, so decrees. I won't talk a whole lot about this. You remember how we had that big purple blob, the whole Utah Lake Jordan River General Adjudication, and we're just taking bites out of it? Well, we will ask for a decree on this particular bite-sized element. And then once we get all the bite-sized elements decreed, then we'll come back in 1,000 years later when we finally get this done, and we'll ask for a comprehensive decree. Hopefully it will be sooner than that. But, it's going to take some time. We're trying to speed things up, but I got a team of like 6 people working the entire state of Utah. So we got to be some elements of realism. Hopefully next 20 years is probably what it's looking like. And that's pretty optimistic in my opinion. So yeah, we come back and we get a final decree on the entire drainage. But in the meantime, you'll still have your portion of your drainage decreed. So it doesn't really affect you, whatever rights are in there. They'll still be decreed rights. But the final decree, we'd like to bring in the federal government. We'd like them to, say, all right, tell us, Forest Service, really, are you irrigating this? Or are you really using this for Forest Service flows, those type of things. So we join the federal government and make sure that they are part of that final decree. All right, here's the map where we're at. You can see the pink blob, the entire general adjudication. And then our portion of it is just this little bite-sized element, Liberty Park, just named after the park up there in the corner, obviously. It's bordered on the north by 900 South and Princeton Avenue, have a little leg jump out there. On the east by 1100 East, on the south by 21st South, and on the west by 300 West. So that's the boundary line. And again, I'll show you after this meeting a map where you can see these boundaries and you can see the little wells and points of diversion superimposed. Sir?
What was the year the last determination was made for this area?
So this question is, what was the year the last determination was made for this area? Never. This is the first time we're getting around to it. Right. I know, right? Seriously, what have we been doing since 1919? Well, we've been doing all these other things, I guess. So we have the Bear River and the Sevier River. So, total number of water rights of record in this particular area is 772. So there are that many water rights that we have on our record that could potentially be recognized in the proposed determination. Now, my experience has been that 50% or more of those won't file claims because they've been long ago turned into Walmart parking lots or whatever. It may be a little bit higher percentage because we have a lot of domestic wells that people are still using them in this area. As you kind of get into the more urbanized quadrant, west of Main Street, those become a little bit fewer and far between. All right. Oh, number of people that we notified as part of this, 8,164. So, pretty significant number. All right.
Notified because you live in that area?
Yeah, exactly. So that's all the property owners in that area.
How many turned out from that 8,000?
Yeah, isn't that crazy? So we had 8,000. So that's what I say when I say that 75% of those claims won't be filed. It's because people aren't interested in this process. You can see we sent out 8,000 notices, and I'm comfortable having a room that hosts about 150. So if that gives you any measure of the level of interest, it's kind of, but at the same time, 99% of those people don't really need to participate in this. But we just want to make sure they're aware of it. And again, this will be streamed on YouTube and be available for review later. Okay, issues. So we see this all the time when we do general adjudications is that so we have all those rights, all these green dots on our records. Well, when they were appropriated, the owners were the actual owners. However, as property is exchanged hands and gone down the line, people have failed to update us with their ownership information. Now, they've updated the property ownership with the county records, but on our records, it's not accurate, and all we can do is send notices to people on our records. And so we have a big issue of out-of-date, what we call title. Now, you don't need to be the title owner of record to file a claim. We want you to file a claim, but if you want to update ownership, there is a mechanism to do that. It's called a report of conveyance, and there are water right professionals who do nothing but these types of things to help you. Again, that's not our wheelhouse, but we can point you in the right direction on how to do that if that's something you desire to do. In the state of Utah, water transferred by a purtenance unless explicitly withheld. So if you get a deed from somebody, regardless of whether it mentions a water right or not, it's implied that it transferred with that deed if the water right was associated with that ground. Now, if they explicitly withheld it in the deed conveyance, then it didn't transfer. So the assumption is that it did convey.
How do you find all that out?
How do you find all that out? A title professional would be able to help you with that, and if that's something you're interested in, we can give you some names of people who can do that. Of course, they charge a nominal fee. Or we can point you to the process, and you can do your own study and do your own research and figure it out.
Is there a website or someplace you can go that has a list of these water rights owners?
Yeah. So the question is there a website where there's a list of all these water right owners? There is. I'm going to show it to you. It's access to our database, and I'll show you who the owner of record is. Show you, and you can look at all the old scan documents from 1902, 1935, and see who originally claimed that water right. And so really the trick is to match your chain of title on your property side down to the chain of title listed on the water right claim.
The reason why I'm asking that is because I live in a home that has been owned by my family since the 1920s.
Mm-hmm.
And I'm just wondering if maybe, I'm speaking of my uncle, if he had water rights, am I entitled to those?
So the question is, he says, I've lived in this house for many generations in the 1920s, and if my uncle who originally built the house or whatnot, and if he had water rights, am I entitled to it? The answer is, if you're the owner of the property, you may be the successor in interest to those water rights if it conveyed via a purtenance. But if it was withheld, which typically are, it's kind of strange, unique situation for those. So the assumption is that if there are water rights, then they would have conveyed. by those deeds. Okay. Okay. So another thing I was going to mention, this gentleman made a good point about that map with all the wells, and again, I'll show that to you. So back in the 40s, there was a kind of a lack of engineers because they're all fighting the Nazis, right? They're all in World War II fighting. So the legislature provided an opportunity for people to apply for water rights and secure those water rights or perfect those water rights without filing a proof. Typically, when you file for a water right, you apply for a water right, you have to file a proof saying, all right, this is what I'm using it for. Here is where my well is located, and it's been surveyed in by this surveyor. Well, there was a statute for a while that allowed people to perfect water rights without having that done. And we call those no proofs required. And they're great. They're great for the people at the time. The problem is that the location of those wells are pretty squirrely, right? And so you'll see our database, and it reflects the location of some of these points of diversion or these wells. But you might say, well, what the heck is it doing in the middle of my roof? That doesn't make any sense at all. You just got to take these things with a grain of salt and keep in mind that since they were supposed to be surveyed in, they were rarely ever surveyed in, and since that we've had GIS, which has a different datum, and so there's some different technical issues that kind of manifest themselves when you look at these aerial images. So just keep in mind, and I'll show them to you. You can look at them. And again, you'll say, well, why is that in the middle of the street? I know my well's in my backyard. That's just kind of part of what is water rights, right? Nothing's easy, and this I wish it were. I wish we just nail those down. But the adjudication part of the process is we come out and we map where they are, and we do locate them where they're supposed to be. So that's one advantage of the process as well. All right, timeline. August 2017. Like I said, in a few weeks, we'll send out the notice to file claims. You'll have 90 days to file those claims. That notice is initiated from the day that the notice was, or that 90-day period is initiated from the day the notice is mailed. In November, that 90-day claim filing period ends. We'll start investigating claims prior to the conclusion of that 90-day period. We'll probably start investigating once we start getting them in. And we've already had claims filed, believe it or not, today and previous. So people are on it already. February 2018, we hope to publish our list of unclaimed rights. That 90-day objection period for the list of unclaimed rights begins. In May of 2018, the 90-day objection period concludes. And then October 2018 is when we hope to publish the proposed determination, initiate that 90 days. Well, you might ask, well, why is there such a big time gap between May 2018 and October 2018? It has to do with if there are any objections to the list of unclaimed rights, we've got to resolve those, and we've got to make sure everyone's in. And so there's a little bit of lag. So, a year from now is when we'll be publishing the proposed determination. And then in January, that 90-day objection period will conclude, and we'll petition the court, once we resolve any objections to that, to decree the subdivision. The question which we've talked about on and off tonight, will I lose my water right? The answer, which I hope I've tried to make clear, is water users who are currently using their wells, or their water rights in this case, in conformance with the records in the file division rights, have nothing to worry about, as long as they file their water users' claims within the prescribed time frame. Individuals using water without a water right of record are required to submit a claim, bring their claim forward during this process, or risk being barred. If you fail to file a claim, you're out of luck, Chuck, from here on out. So, let's make it count. If the water use authorized under the water right has fallen out of use for a period of 7 years, a portion of the water right or the entire right could be disallowed in the proposed determination process. That's that 7 years use it or lose it time frame. And since that concludes my brief, I'm happy to answer questions. You got your hand up first.
How do your inspectors determine usage if it hasn't been used for, say, 5 years?
Well, that's a good question. So his question is, how do our staff determine usage if it hasn't been used for a period of, say, 5 years, which is less than 7 years? The answer is we do our best. We make a recommendation to the court, and if people don't like it, I guess they can object to it, and then we deal with it there. But honestly, we're not out to be mean. We're not out to screw anyone out of their water rights. We are honestly trying to protect people's water rights because it gets us nothing but discontent if we try to do it the other way. I mean, like I said, we don't like to make enemies with people. We're rooting for you. You know, bring your claim forward. Let's see what we can do. Let's make sure we recognize it. Yes, ma'am.
What kind of documentation is required, if any, if you have a claim already on there, or if you don't have a claim? Is there any documentations that are required in this process that we need to provide other than the claim?
So her question is there any documentation required, whether your claim is of record or your water right is of record or not of record, during this process? And the answer is it depends. So if you have a water right of record, a lot of the information is going to be there on our files already. And we can use that, as long as you file your claim, we can use that to do a pretty good evaluation. Now, if your water right is not of record, you are going to need to justify the proof that it was put in or is appropriated or used prior to 1935 for groundwater or prior to 1903 for surface water. And so you need to get us over that 50% threshold, right? It's more likely than not that it was used prior to that time frame. So there is going to be evidence on your part that you'll need to provide in order for us to make a satisfactory recommendation to the court in line. Did that answer your question? Kind of? See me afterwards and we'll talk it out. Sir?
I understand the process, and I'm wondering if it can be somewhat simplified in some areas. For example, every year we have a meeting for our water users group. We have a mediator that attends. We have the water masters that attend. We have a recording secretary that keeps track of who's at the meeting and who the water users are. And the recording secretary has kept that list for years and years and years and years and more years. Is there a way that you can coordinate with the water master, get a copy of that list that would simplify the process, maybe not so much that we don't have to fill out the form, the claim form, but so much from the standpoint that the water masters know who uses the water. Your people would save a lot of time rather than coming out and visiting whose property. You just coordinate with the mediator.
So it's kind of a long, so I'm just going to repeat the question for the sake of the audience here. He talked about they belong to a water users group that meet annually, have minutes, and have a water master that presides, and kind of they take care of their shares and then they air their grievances and those types of things. And is there some way that we could simply get with them in order, rather than having to have everyone evaluate all of those? And we certainly hope and we expect Salt Lake City to participate in that. I presume that's who is the water master for this particular group. And so, yeah, we will do that. We do expect Salt Lake City to come forward and justify their rights and their claims just as any other water right holder. So Salt Lake City will do that on your behalf. And so that speaks to the point of, do I really need to file a claim if I'm simply a shareholder? And the answer is no, because the owner of the water right, Salt Lake City, would do that. But again, I don't want to say that definitively because I'm not completely certain how that exchange works out. Yes, sir.
Sir, I'm the mediator for Parleys Creek Water Users Association, and the city's going to take care of it all. It's going to be fine, and that's one of the reasons why I'm here, to make sure everybody understands. It's going to be good.
Good.
No problem.
So if you have questions about the Parleys Creek exchange, this gentleman is certainly, yeah, you probably all already know him. And he just wanted to reconfirm for the sake of the listening audience, Salt Lake City is going to take care of it. He's going to, and I will, I agree there. Salt Lake City has been a partner in this process from day one. They're very involved, and we are on a first-name basis with Laura Briefer, the director of the public water supplier, the Salt Lake Public Utilities, and her staff. So I just echo your sentiment. And you're going to meet with her tomorrow on it. Great. Yes, sir.
What is the web address to
I'll come back to you. Yes, sir. Go ahead, sir.
I was interested in your previous screen. You mentioned Federal Reserve. What is the Federal Reserve's involvement in our water rights?
This is not the Federal Reserve. Not the
Federal Reserve.
Federal Reserve water rights. Yeah. Sorry. Yeah. We need a comma in there, right?
Connection to the money.
No. Okay. Thank goodness. No. It has nothing to do with.
Bruce, I tried to contact the mediator. Secondary question here, and their phone lines are like off the hook or something. So.
I'm not sure who you tried to contact.
The lady said you contact Bruce. He's a mediator. and I tried to contact the phone number that they gave to ask for extra information. Phone lines were useless.
Well, I'd tag him tonight or get this gentleman and talk to him tonight. Make sure he doesn't leave without you talking to him. So, all right, I'm going to go over here. This gentleman.
I had an artesian well on my property, and the city came and drained it. Where do I stand?
So his statement is he had an artesian well on his property. The city came and drained it. Where do you stand?
I have the abstract that says I still have water rights.
Okay.
That came with the property.
So he says he has an abstract that came with. So it comes back to have you used it in the last 7 years?
It was taken away from me without my choice.
So, so the gentleman says that the Salt Lake City, probably by pumping, I'm not sure how you say they drained it, or.
I think they intercepted it.
Okay, so in some way the well was impaired. Where does he stand with the water right? The fact of the matter, unfortunately, with groundwater is you are required to go after it. So as the water table drops, you've got to continue to drop your pumps lower and lower. And in this case, you're not. I certainly empathize with you because you're not alone in that regard, where people have been impaired, whether it be by city or by other wells going on or whatever, just the circumstances of the groundwater dropping. But the law is if there's groundwater, and you and I can talk offline about this.
Water didn't drop, they drained it.
Well, we can talk offline. I'm not going to debate on the hydraulics of a well, but I'm certainly have that discussion later for our benefit if you'd like to get some insight. I'm not sure that I'm going to give you any insight that you're going to be willing to accept, however. Just a sneaky feeling. Sarah, I know, I'm kind of working. I'm going in. I got a system down here, so I'm going to work back over here. So, sir. So his question is, if I see a water right on the map that appears to be in someone else's name, what is the process to get that transferred into my name? It's called a report of conveyance, and it's what I discussed earlier. You would have a water rights professional or a title professional help you or show that chain of title and then bring that up to date on our records. And we can certainly point you in the direction of our title professionals. Actually, Teresa Wilhelmsen, she can raise her hand. She's the assistant state engineer over appropriations and records, and her office is the one that does those reports of conveyance. I'm sure she'd be happy to answer some questions. The question is, will they do an inspection? The title portion won't do the inspection. Our staff will still do the inspection regardless of whose ownership. So what I suggest is make the claim in your name. We'll evaluate it, and then you can always settle title issues later on. That makes sense? All right, let's go. Sir?
Quick question. First, just a comment. You can go down to the county recorder's office and do all that research yourself if you want to. And they're helpful, and they will help you do it. It'll take you a whole day or more, but you can do it and bring in all those sequential warranty deeds.
Yeah, so let me piggyback on what you said, just sort of the sake of the camera here. You said you can go down to the county and do all that research yourself and find that chain of title, with the caveat that it's still at the end of the day, if it transfers by appurtenance, has to be signed by a title professional. So at some point, you have to bring a title professional into the work.
Second question. Question is, after the adjudication inspector evaluator comes out, will the property and makes a recommendation to be included in that proposed determination? Before that proposed determination is filed with the court, will the affected property owner get a copy of that proposed determination so that they can
That's a great question.
So you can go through your administrative
great question
before you go into court?
Yeah. So the question is, before we enter our recommendation to the proposed determination, will the water user have an idea of what we are going to recommend? And the answer is yes. We'll come out, we'll investigate it, and if it's different than what you have claimed, if it's what you claimed, we're just going to move forward and recognize it. If it's different from what you've claimed, we send out a response. We'll send you what we call a state engineer's recommendation, which looks like a water user's claim, with how we think the water right exists. as well as with a map of what we've mapped on that property. So then you can take that and say, no, hold on, time out. No, I disagree with what you're saying, and this is why. So, because we want that dialogue, and we want to facilitate that.
And we could request informal hearing.
So this question, you can request informal hearing. There's no real hearing involved. It's just a matter of coming in and talking to us. And then at the end of the day, you get your day in court if you want to file an objection. And that's where the true due process hearing takes place. Is there a question over here? And then I'll circle back. I'm going like this. I got a system. You got to be patient. Yes,
just out of curiosity, there are several places that are shown on that map that have above ground water creeks.
Okay.
Some of them like around Fairmont and also like 14th South. There's areas where the water goes above. Do they automatically have water rights?
So her question is, well, her statement coupled with the question is, in some areas there's surface manifestation of water, creeks or ditches or whatever being conveyed. Do the property adjacent to that have an automatic water right? And the answer is no, they don't. They may have a water right if that's something they've applied for or been using, but it's not automatic. That would be what we call a riparian water right, and we don't do that west of the Mississippi for the most part. Okay, I'm going to go back to this side now. I got you coming back. Is there any over here? Okay. Do you have a question?
Yeah, just a web address where you can look up these water rights. Or...
Yeah. So if you go to waterrights.utah.gov, and like I said, once we kind of wrap up with the questions, I'll pull it up on the screen and kind of show you how to access that. I just want to get people who had burning questions. Are we ready to do the map presentation? All right, then first you, and then you, ma'am.
After the adjudication whole process, are they going to be checked every 7 years to make sure they're still in use?
So the question is, after the adjudication process, is it going to be checked every 7 years to ensure they're still in use? No. Now, that doesn't stop someone from, if your neighbor really disliked you, they could always rat you out and take you to court and say, hey, he's subject to forfeiture. But no, like I said, we've got to continue to move on down the road. Now, that's not an excuse to simply, once you pass this process, just to not use a water right. Hopefully that's not what you're thinking. Right. I doubt it is, but no, we're not coming back in 7 years, to my knowledge. Of course, I could go on 7 years, who knows.
I have a two-part question. Does this process change any of the rules regarding selling or buying water rights? Does an individual who has a claim to a water right still have a right to sell it, or can an individual buy it from someone like that? My second question was, when the list comes out of unclaimed water rights, is it possible for a person who wants to purchase a water right to buy one off that list?
So our first question is, does this process affect in any way the conveyance of water rights through purchase and selling? Thanks. The answer is no, but I'm going to say this right now. You can buy and sell whatever you want to buy and sell, right? Now, it's up to the purchaser to do due diligence and make sure what they're purchasing is a valid water right. And that kind of segues into your second question is, once this list of unclaimed rights comes out, can you go and purchase one of those rights? Oh yeah, I bet there'd be lots of people willing to sell you one of those rights, but you'd be buying nothing, right? So
did you go through a title company?
No, really what you're talking about is, so there's always the due diligence. You got to make sure that who you're buying the water right is the actual owner of the water right first. And so that can be done through this reported conveyance process, but I'd be very careful in purchasing water rights. I'd be sure, first of all, that the person selling the water right is the owner of record on our database. Okay, that's step number one. And then any other due diligence just to make sure they haven't already sold it to someone else or whatever. So it's the standard rules of due diligence of purchaser beware, buyer beware, is the same thing, right? But to answer your question with a list of unclaimed rights and purchasing one off that, I wouldn't. That'd be like throwing money out the door because those are going to be abandoned, right?
Thank you.
Yep. I'm going to go over here and then I'll come back. Yes, ma'am.
So I'm a new owner and I'm the person of record. If I go to your website and see I'm not a person of record, do I need to spend the money to get a title person to get that during this process, or can I just let the process play out?
So her question is, I'm a new owner. I'm not sure if I'm the owner of record on your database. If I'm not, do I need to spend the money now in order to update title on your records during this process, or can I wait to let things kind of shake out and then do it? So the answer is you can wait to let it shake out. I would encourage, I'm always a proponent of updating title, because if you have a well and you need to get it fixed, you can't do that unless you're the owner of record for that water right. You can't, a well driller won't come out and renovate a well without it being the owner of record requesting the service. Okay. Did you have a question, sir?
I do. Question, when the summons were mailed out, there was another summons in the mail with somebody else's name on my address.
Mm-hmm.
So is that, when you do that title search to get that cleared up?
Yeah, so it's a great question. So he said, hey, when the summons was mailed out, I received 2 of them. One had my name on it, one had some other person's name on it, right? So what that probably means is there's a water right associated with your property. It's probably still in the name of that other person on our records. So that's a good, and you'll see the same, and so what will happen when we send out notice to file claims, you'll receive the same type of notice, except one of them will have the water right with that person's name on it, and it will be filled out with the data on our database.
So do I go to the county for that, or how do I get that?
So how do you get it? How do you get the person's name on? It's that same report of conveyance that you need to do. Okay. You bet. Is there a question over here?
Yeah, I have
Yes, ma'am.
there's an artesian well in back of me and one to the south of me, but my property, I'm using the well that's to the south of me, and they're not here tonight. But could I claim a water right and drill a well on my property?
So her question was that she has some artesian wells on her adjacent neighbor's property. You utilize the well, I presume, for irrigation or something to that effect, right? Can I claim a water right on that well? You know, my gut reaction always says file a claim and we'll figure it out. So you know, you may or may not have a water right. It may or may not be justifiable. But if you don't file a claim, then you're out of luck, right? So if you file a claim, we'll come out and we'll figure it out.
We did this in South Salt Lake. My wife did this on our property, and I don't know if this answers the question, but the well is on my neighbor's property, and he lost his water right, but we share the well, and we have the water right. And so my wife went through the process, got the water right, and it's odd that the well's on his property and it's piped over to our property.
And that's not too uncommon. That happens a lot. So often what will happen is you'd have groups of houses that would appropriate one well for the groups of houses, and they would share that well.
Yeah.
I'm not sure if that's the case in your scenario or not.
When I did a research with the water department, they said the person owned the aquifer for all those wells. There's like 4 of them around me. And the person behind me owned all of them.
All of the water rights associated
right
with
to
those
all
wells.
of them, but I guess that's changing now, right?
Well, you can always, so kind of sometimes what would happen is you'd have a developer buy a chunk of land, drill a bunch of wells for houses, sell those lots with the wells, build houses, right? And so, because that was how they supplied water to their houses. So he would file claims on those rights, and they were always in the developer's names or in the original landholder's name. And so what's failed to happen is those owners have occupied those houses, they haven't updated the water rights ownership. They've updated the ownership of the parcel with the county, which is the record, the official record, but they haven't updated the water rights database or the water rights division with that. So I don't want to say no, you're out of luck, and I don't want to say yes, you got slam dunked, but my suggestion is, hey, file a claim, we'll figure it out. And if it's like this gentleman's scenario, yeah, certainly, we'll figure it out. We'll want to maximize that right, assuming that it's within its original appropriation boundary. So the caveat is, if someone drilled that well and it was for this specific house and that specific yard, and you're using it on this yard, and they file a claim for that, we can't recognize your component because they filed a claim on theirs and it was only appropriated for that, and you've simply used it beyond its authorized use. So I just want to make you aware. I'm not saying that's the case, but just be cognizant that that scenario exists.
But could I get a water right and drill a well?
Could you get a water right and drill a well? You would have to acquire a water right. Now, you'd have to acquire a water right. This is tricky because we kind of got to know what your scenario, the parameters of your scenario are. But the short question is, if you want a water right, you'll need to acquire a water right and drill a well with it. Okay, and by acquire I mean go purchase.
So I'm in the right place to acquire a water right.
Well, maybe. I don't know. It depends. There's like I said, I hate to get so far in the weeds because you grasp onto everything I say and you're sure you're going to get a water right out of this thing. Maybe. And it's potentially possible, but without knowing all the details, it's really hard. But once we have the details, we can give you some advice on how to do that. Okay, so there's hope. It's not a whole lot of hope, but there's hope. Yes. Yes, ma'am.
I think probably what she's asking is, can you apply for a water right through the state?
So can you apply for a water right through the state? In the Utah Lake, in this area, the basin is closed to new appropriations. I mean, you can't apply. In other areas, you could do that, right?
So you can buy one from someone else?
Correct. You would need to purchase a water right from someone and then file what we call a change application and move that water right into your well. Yeah. Sir?
Did you say those maps are going to be outside, just outside the store?
There are some hard copy printed off maps that were outside in the hallway.
And then,
unless people have taken off with them.
What
What are the value? What are these water rights worth? I always like to answer that with another question: how many pancakes does it take to shingle a doghouse? I don't know, but the free market knows. So you put it there. So I'll put a plug in for it has no affiliation to Division of Water Rights. There's a website called waterrightsexchange.com. And you can go and see what they're worth there. I don't, because I don't live in this area, and I don't really. And quite frankly, if I marketed water rights, I think that'd be a little bit of a conflict of interest. But I don't know. Teresa, you have any feel for what an acre foot goes for in this neck of the woods? Yeah, exactly. It's whatever the clearing market rate is, right? All right. Yes, sir.
It also has value. I was going to give you some prices.
Yeah, you can talk to this gentleman. So, are we ready to go to look at the map really quick? All right. I just got to fire up my hotspot really quick. Maybe. Okay, so this is our homepage for the Division of Water Rights, okay? The address is www.waterrights.utah.gov. So if you'd like to go to this map interface, the easiest way to do it is to go to this data link at the top. It'll open a menu. Second item down is GIS/maps. Select that link. In the upper left-hand corner, there is a link called Water Right Maps. Select that link. And so most of all of these maps will get you the same place, okay? But since we'll just say, click on the first link that says Adjudication Areas, just because I'm an adjudication guy. And it's a little cumbersome to navigate without a mouse, but I'm going to do my best here. The mouse, you can kind of scroll in and a little bit more delicately here. But so you see all these purple lines on this map. These correspond to those subdivisions I was talking about, the adjudication subdivisions. One of which is the Liberty Park, right there, 57-11. Okay. And as you zoom in, the aerial imagery will become more. It's just like Google Earth. It's Google Earth for water rights. All right. So I'm going to zoom in and just so you can see, and I'll turn on the layer. So you see on this left, on the right-hand side, this menu, okay, that shows layers. What you'll want to do is select the button that says Points of Diversion, okay? And it will bring up all these little icons. And these correspond to known points of diversion. You want me to go further up, further north? These correspond to points of diversion that we know of on our water rights database. So if you see your house, you're like, well, that well appears to be in the general vicinity, you can select the link, and it'll bring up this little menu. And then this hyperlink, so this is the water right number. So everything we talk about, so this 57 is the 57 area, and then this is the water right number. So this is water right 57-6862. You can see some information. That's taken from our database, but if you select the link there, it'll actually take you to the printout of what is on our database. Let's give it some time here. So this gives all the details with respect to the water right. So you recall, oh boy, it's off the screen, is it? Here, let me do this. Let's do that. So you have the owner of record right here. You have the priority date, 1894. You have the type of right. So this is an underground water claim. So what that means is this is a well that was drilled before 1935, as evidenced by 1894 priority date. So they call those underground water claims. The flow rate is 0.022 CFS, or cubic feet per second. Now you'll see this point of diversion description. This is how we measure points of diversion using public land survey system. This means is south 1715 feet, west 1620 feet from the northeast corner of section 18, township 1 south, range 1 east, Salt Lake Basin region. So that's gobbledygook, right, to most people. Don't worry about that. The takeaway from that is it corresponds to this location, okay? And I could show you, you can bring up the public land survey system if you really wanted to dive into it, but I'm not going to. There's lots of different layers you can play around with, click through and see. So right here, there's all kinds of things you want to play with, you can play with. You can even go with base map and check out different types of imagery, and even if you wanted to pull up the topo map of the area. So, but traditionally, I like the Google imagery. It's a little bit cleaner than most, so that's why I default to. And these just correspond to the addresses of those houses. So you can use this, kind of zoom to your own law, your own house, and see what water rights or wells of record are in that area. Keeping in mind that that doesn't mean that if there's a well that there will be a red dot associated with that. What street is that? That is Bryan Avenue. Yes, ma'am.
I think I blinked when you got to Division of Water Rights and where did this layers base map search?
Oh, okay. I'll walk you through it one more time, or another time. So if we go to the Division home screen, no blinking, all right? Pay attention. Data, GIS/maps, select that link. Go over here to water right maps, select that link, and just pick the first map in the column. These are pretty much all the same, but this gets you where you need to be.
And that stuff's automatically on the right. Okay,
Yep.
That's where I got lost. I thought you did something to...
No, it's pretty intuitive for the most part. I mean, if you can navigate an iPhone, you should be able to handle this. So, and if you do have questions, we'll walk you through it. Call us up or come in.
So about points of diversion.
Yeah, these are all kind of, and so if you zoom out, you'll see what I'm talking about. It's just, it becomes so clustered with points of diversion in the Salt Lake Valley. It'll only, well, that's just a portion of it. It will only show up to like, yeah, so you can see all of these wells. Now you'll see that there's pretty dense down here, but it gets less dense as you go up here, right? And that's just the nature of the beast. Is, you know, a lot of associated with these flowing wells. There was a lot of wells drilled, and so as you kind of go east of, what is that, 7th East or something, they start to not having as much. They didn't have as much groundwater so available, so they didn't really drill very many wells. But you have these little blue icons, and those are surface water rights diverted from streams or creeks, right? So red are the little well icon, and blue squiggly water are surface icons.
What's white?
White. Is there a white one? Are you talking about this thing up here?
Underneath the red. All the white.
Oh, those are just all the numbers. It's just stacked on top of each other. It's kind of hard to see, so that's why you kind of got to zoom in on these areas. They get a little bit easier. So in some cases you have two or more water rights that might be in the same well, which is a possibility. You just select that, and then you can expand that. So pretty, I think it's intuitive, although you know, I work with it every day, so it's easy for me to say that.
So you have a map of this out there? Kind of.
Yeah, kind of. I mean, it's obviously not as cool when you can't turn on all the layers and stuff like that, but we printed off a large map that you can look at and kind of get the big picture of the entire.
And one of these little ones, the little wells on it?
Yeah, it'll show all the dots on there.
Okay.
Pink, that just means there's 2 or more stacked wells or water rights. You talking about this?
Yeah.
There's 2 water rights in that well, so it just puts a bubble and says 2. So if there were 5, it'd be a bubble and say 5, and you hit it and it'll expand.
Well, that just means they have.
It just means that there might be more than, so let's look at one. So here you have a water right owned by John G. Osborne and one owned by E.J. Allen. So remember I said in some cases they would drill one well and multiple houses would share it. That would be a case like this where they have one well, but you have multiple water rights coming out of that well. Okay, do you have anything to add, or you have anything to add? You good? Okay. Any other questions? Happy to answer one-on-one questions if you want to have that discussion. We have that discussion. Like I said, I don't think you're going to come away any happier than you are now.
To recover the rights to it and do something.
Okay, well we can talk about that.
If I know it's an artesian well, it's pressurized by groundwater.
Right.
It's not like.
All right. Yes, ma'am. As what? Oh, sulfur, yeah. Yeah, so the groundwater quality in some areas is not great. You know, there's certain areas, especially in Salt Lake Valley, where you have this sulfur taste to the water. And then there's also places where you have hot springs, and it's affected by volcanic activity, believe it or not. So some of these waters are heated by volcanic activity. And I'm not sure if that has something to do with it, but you have water quality issues, and that water can taste like sulfur. And so a long time ago, Salt Lake City Public Utilities, you know, tapped into the clean water of Parley's Creek and offered clean water to everyone. A lot of people said, forget my nasty tasting well that only flows in the springtime or whatever. I'm going to connect to the city water and just let that well that's leaking all the time go to waste. You can cut the stream, Paul. Yeah, I don't think we need it for anyone. It's the same water, it's groundwater. Yeah, it's just, you have shallow water table in some of these areas. And some of that is what manifests itself in these flowing wells. But in some areas it's not confined and will just flow up. And if you have a shallow water table, sometimes you have to flip on a sump pump to do water in your basement.